Lord Waldegrave, we touched before the break on Mr. Clark's willingness or otherwise to settle. I wanted to turn briefly to Mrs. Thatcher's willingness or otherwise to settle, because your sense, as set out in your statement, was that you were more willing to settle the claims than Mrs. Thatcher. And I just want to look at two or three documents and then pick that up with you. If we start with WITN 5288011, this is a letter the 7th of November. So you've been in office about 5 days by this point in time, and it says, you copied to me your letter of the 18th of October to Stephen Alcock. In turn, I'm copying this letter to Stephen also, so that's your principal private secretary. The Prime Minister has inquired the possibility of an expedited hearing for these proceedings, and your Secretary of State has agreed to provide advice. However, I understand that the trial judge has already ruled that there can be no preliminary trial of the legal issues involved. Furthermore, the listed date of 4th March 1991 is felt to be the very earliest that the parties can sensibly adhere to. And you observe in your statement, looking at this letter, that it corresponds with your understanding that Mrs. Thatcher was content for the matter to be fought out in court. Is that right?
Yes, that's right.
And then if we look at HSOC 0012332, this is a letter dated the 2nd of November 1990 from Mrs. Thatcher to Alf Morris, MP. It's the date upon which you were appointed Secretary of State, so highly unlikely, I think, that you would have seen it before it went out. The inquiries looked at this letter before, so I just want to go to the last paragraph on the second page. Mrs. Thatcher, having set out various observations about no-fault compensation, then says, I'm sorry if this is a disappointing reply, but the government is showing its great concern for haemophiliacs with HIV by the ex gratia payments it is making. The question of compensation has to remain a matter for the courts to decide. And then if we turn to a departmental comment on that letter, it's at DHSC 0020866_100. It's a minute dated the 9th of November 1990 from a Ms. Stewart to Mr. Kendall, not a document copied to your private office, but it says this: I see from today's Independent that the Prime Minister has written to Alf Morris saying that any compensation is a matter which must be settled in the courts. Thus, it is speculated, preempting any choice Mr. Waldegrave might have had in the matter. Do you have any observation on that last sentence?
As I say in my statement, I'm sure that the letter from Mrs. Thatcher, from the then Prime Minister, to Alf Morris was merely a maintenance of the existing policy. I'm sure she wouldn't have. It wouldn't have been in the mind of the private secretaries in Number 10 that they were doing anything odd by sending the same letter that I think Virginia Bottomley and others had sent. I think it was drafted in the Department of Health.
The Independent article that's referred to there is at DHSC 0020866_103. And I think if we just look under the large heading, not relevant, thank you, Lawrence, it's really only the first paragraph. It says the Prime Minister yesterday blocked any chance of William Waldegrave, the new Health Secretary, reaching an out-of-court settlement for haemophiliacs with HIV or AIDS. I'm not proposing to read through the rest of the article.
The article, it seems to me, shows a complete misunderstanding of how Mrs. Thatcher's character and how she would have worked. If she'd wanted to stop me doing something, she wouldn't have written a letter to an opposition Labour opponent. She would have told me.
Your observation, in any event, it is in paragraph 4.17 of your witness statement. So WITN 5288001, page 36. Paragraph 4.17, so top of the page, you refer to the Independent article. If we pick it up in the last 6 lines or so, you say, I therefore see no grounds to suggest that this can fairly be read as Mrs Thatcher seeking to preempt the situation, let alone block me. Nevertheless, I was aware that the Prime Minister's view was in favour of letting the courts decide the matter, and I would have known it would be a sharp battle, but not an impossible one, to get her to change her mind on something which she had defended in public.
That's correct. I'd had experience of arguments with her as a junior minister in the Department of the Environment. It was always alarming, but sometimes she would change her mind. Not always acknowledging that she'd changed her mind.
In any event, it was not put to the test, obviously, because she was very soon succeeded by John Major. Do you recall whether you had any specific discussions with Mrs Thatcher about the possibility of settlement or the need to continue to court hearing in the 20 or so days between your appointment and her resignation?
No, I have no memory of that.
Can we then just pick up a couple of documents? It's an exchange of letters between you and the Haemophilia Society. HSOC 0017272. It's a letter dated the 3rd of November 1990 from the Haemophilia Society addressed to you. If we go down to the text of the letter, congratulates you on your appointment. The next paragraph deals with what's said to be a need to correct some false impressions within the department. I'm not proposing to ask you about that. The third paragraph reads as follows. It's been open to the government since 1986 to settle this matter in an open-handed manner without the need for litigation. The matter only became one of public and political interest because of the piecemeal fashion in which the government has chosen to deal with it. Contrary to the view which has been expressed by the department in recent weeks, I would want to quietly remind you that the payments which have so far been made to the Macfarlane Trusts have only been made as a result of very hard campaigning by ourselves. This in turn generated widespread political and public support. It is also surprising that in recent weeks, those ex gratia payments have suddenly become payments made from a sense of moral responsibility. The suggestion there that the payments hitherto made had been made as a result of very hard campaigning, which had generated widespread political and public support. Is that a fair comment, do you think, based upon your understanding of how matters have got to the position they were in November 1990?
Well, all senior ministers, all ministers, are used to being campaigned against on a huge range of issues. And sometimes they are persuaded by the campaigns and sometimes they're not. So it's a mixture. Of course, the campaigner will always claim that that it's all down to them, and the minister will say, well, it's actually down to me because I've changed my mind. And it's a bit of both, surely. But there were plenty of campaigns which ministers had to resist.
And then if we can just look at your response to this letter, there's just one point I wanted to explore with you. It's DHSC 0004365_032. It's a response of the 26th of November 1990. We can see if we go over the page. It's from you, and then if we go back to the previous page in the text of the letter, it's the third paragraph. You say this, perhaps in turn I might make the government's position clear. Those taking legal action are of course entirely free to do so if they believe they're entitled to compensation on grounds of negligence, but it is their own choice. The government has not encouraged them to take such action. Indeed, by providing financial help totalling £34 million for HIV-infected haemophiliacs and their families, with an undertaking to keep the sum available under review, we have shown that it's not necessary to take legal action to secure financial help. Now, I'm not going to ask you about the previous two payments which had totalled the 34 million or what had prompted those. Those predate your time in office. But in terms of the suggestion not necessary to take legal action to secure financial help, would it be right to say that the action that you then took, which secured the funding, as we'll see shortly, to settle the litigation and provide further financial assistance to those infected, really was only forthcoming because of the litigation, was it not?
Well, certainly the litigation was at the forefront of people's minds. Yes, it was. It was part of the circumstances, I guess, and if that's the right word, that led to where we were. So proving a negative is so difficult, but who can have said what would have happened in other circumstances? It's difficult for me to comment on.
Now, if we turn then to the settlement proposals that you were then asked to consider in the course of November and early December 1990, DHSC 0046962067. This is a minute from Mr. Dobson to Mr. Heppel and to Mr. Alcock, your Principal Private Secretary, 9th of November 1990. And we can see paragraph 1 says, I attach a copy of a proposed scheme of compromise which we've just received from the plaintiffs. A very preliminary assessment follows. We will submit our considered advice to Secretary of State on Monday. I'm not going to go through the scheme of compromise itself. We've looked at it in earlier hearings, but for the record, it's at DHSC 0003654117. You say in your statement you think it's virtually certain you'd have either seen the compromise document or have been briefed on its contents.
Certainly, yeah.
And if we look at paragraph 3 of this minute, it explains that paragraph 2 of the proposal points out that it is made with the authority of the steering group of the plaintiff's solicitors, but without the knowledge of their clients. There is therefore no guarantee at this stage that the steering group would be able to sell the proposed settlement to all their clients. Before Secretary of State gives any degree of commitment to a settlement along these lines, we believe that he should seek an assurance from the plaintiff's solicitors that the vast majority of their clients will sign up to it. So you would have known at this point that this was a proposal that was coming from the plaintiff's legal representatives, but without the agreement or even the knowledge of the individual plaintiffs themselves.
That's what the minute says, yeah.
I think your statement tells us no independent recollection now of what you thought about the level of settlement, but you think your reaction would have been one of delight that the offer was made at a level that was not, the way you put it in your statement, impossible to deliver.
That's right. I mean, perhaps as a new Secretary of State, I was overconfident, but I thought surely that's a sum we can deliver.
And your statement tells us you knew, however, that this was money you'd have to secure from the Treasury because you would not be able to find that amount from the Department's existing allocation. Yes. If we look at DHSC 0020866_083, these are some handwritten notes which refer to there being a meeting on the 19th of November. It says the meeting's at 4:30 p.m. in the Secretary of State's room, I think that says. And then various documents are referred to as attached. And we see from other documents and from your statement, you had a meeting on that date with Council Andrew Collins QC and a range of other officials. You don't, I think, recall that meeting specifically, but would you expect there to have been some formal minute or record of it?
I would, yes. I've always found this piece of paper rather odd. I'm not quite sure whose handwriting it is. Do we know?
I think it's Mr. Kendall.
Mr. Kendall. And then somebody else has written aberrant judge, which is presumably referring to Sir Harry Ognall. But that's somebody else.
And that's not your handwriting or your comment?
It's not my handwriting, no. So it's an odd piece of paper, but there it is.
We can see that the item C there refers to a copy of a note from our council reporting a meeting with the other side's council. And I just wanted to ask you about one passage in that note. It's SCGV 0000230_018. We can see the covering document there says, I enclose a note of a meeting between Andrew Collins QC, DOH's counsel, and Rupert Jackson QC, plaintiff's counsel. And if we go over the page, Mr. Collins sets out his account of his meeting with Rupert Jackson QC. I don't want to read through the detail of it, but if we could just go to page 7, please. I just wanted to ask you about the last paragraph where Mr. Collins says this: I'm sorry to burden you with this, but I thought it was easiest to put it in writing. I'm assuming you'll forward a copy of this letter to the Secretary of State's private office and to whoever in the department ought to see it, including in particular one of the lawyers. And then this, I've headed it confidential in an attempt to reduce the chances of a leak. Now, the significance of leaks will emerge shortly when we look at the circumstances in which the settlement was announced by John Major and by you. But we've got here the department's own leading counsel referring to the possibility of a leak. Two questions. First of all, was there a real problem with leaks from the Department of Health at that point in time?
Well, I think he's not necessarily, it's difficult to say, accusing the department of leaking. It might have come from anywhere, from either the victim's lawyer's side or solicitors or others. I mean, there's a lot of people involved. And when you've got people outside the department and inside the department, things can leak. And this is a very... I don't think the Department of Health was a particularly leaky department, as far as I remember.
And what was the worry about there being a leak? Why was it a concern?
That becomes acute later on, in my mind, that we had a chance of a settlement put forward by the victims' lawyers, which was the Department of Health and the Treasury were both saying this is high, and on the high side, says Strawn Heppel, I'm going to have great trouble getting the money from the Treasury. And on the other hand, there is the anxiety that we would have what I think is referred to in the papers as a public auction from the other side. And I believed that this was one of those moments that sometimes happen in any negotiation where there was a chance of agreement, and that if you went for it quickly, it could be agreed. And that if there was long process of discussion, whether public or private, it was very likely to come to pieces and we'd be back where we were in the first place, which I thought was a horrible position, both for the victims and for the government. That was why I was so anxious for speed. And I noticed that in the notes from Rupert Jackson, he talks about the need for speed. There's 15th of November, please reply by. One other thing I may say, if I may, it's so difficult to remember what is a genuine recollection and what is a recollection stimulated by the papers. But I became very impressed by the lawyers, by Andrew Collins and Justin Fenwick, and by their account of Rupert Jackson, whom I came to understand was one of the leading lawyers in the area of industrial injury and such matters. Their capacity for negotiation and and speed of action seem to me to be greater than that, perhaps I'm being unfair, but greater than that of the officials. They were used to dealing with situations like this, and they were giving me strong advice that there was a deal on offer here if I moved quickly to take it.
And then just wanted to ask for your observations on another handwritten document, the origins of which I'm afraid are unclear, DHSC 0020866_084. There's a question mark and the word phasing above, reference to Andrew Collins and Michael Spencer, who were two members of the department's, of the Central Defendants Legal Team. And then there's this, well, first of all, is this your handwriting or handwriting that you recognise?
It's not my handwriting, much neater than me, and I don't recognise it.
And then we've got the reference court of public opinion, and then for letter to Lamont, I think that might say. Problems delivered this awkward, I'm not quite sure.
Awkward cuss.
Yes.
Someone is being labelled here, I think.
Oh, awkward cuss, yes, SAC, yes.
And then there's a question, why concede? And then there are 3 points. 1, unpop by not settling. 1A, legal aid costs avoided. 2, likely to win, but still seen as heartless, would have to put more into McFarlane Trust. Therefore, for small extra cost, could get goodwill now. Consequence, future consequences. Now, it may be this is dealing not with the period of time with which you were in office, but with earlier decision making. But leaving that aside, there are those 3 factors there identified: unpopular by not settling, legal aid costs avoided, might be seen as heartless. To what extent were those factors that were relevant to your thinking about settlement?
Well, I think these are general considerations that seem common sense to me. People of goodwill wanted a settlement. There was future consequences of the arguments against. I mean, these are some of the arguments that are swirling around, aren't they?
If we then come to a further...
It doesn't look to me like departmental paper, but I may be completely wrong.
No, it's a document, the origin of which is the Department of Health in terms of its provision to the inquiry, but it's obviously not a formal minute of any kind. If we then just turn to HSOC 00...
It looks from its nature as though there's something written on the back of it, as though you can see through. So the original may have been thin enough to allow for that, and that might suggest it's part of a notebook or something similar. Well, I don't know if that helps.
Yes, well, if you look at the...
I'm afraid I have no idea where it comes from.
Well, so the text that you appear to be able to see, I think, is the text of the letter that we looked at, or the note we looked at previously. Because if you look at the box, top left-hand corner there, that's the words aberrant judge in reverse.
You're right.
So it is, you're quite right.
And one can actually map down the rest of it and the underlining towards the bottom of the page.
And it's the same handwriting, isn't it, I think?
So I think that's why it's been associated with the former document, but whether in truth it refers to those discussions or to something else, I think it's not possible to ascertain.
Well, if it is that former document, it would suggest that it is someone within the civil service, even though they're not using they're probably using their own notebook or something.
Yep.
So if we could then just look at HSOC 00-12354_002. This is now 22nd of November 1990. It's a press release from the Haemophilia Society. I'm not going to read through the details of the first page. If we could go to the second page, we can see in the second paragraph it refers to a plea for an out-of-court settlement. And then fourth paragraph, Because Patrick Cormack, in setting out the group's action plan, said, "We're not asking the government to admit legal liability. In this case, we want it to quantify its moral responsibility." And it's that concept of moral responsibility I just wanted to pick up with you again, Lord Waldegrave. Leave aside what might have been in the thinking of the Treasury or anyone else. Was it your own view at this time that there was a moral responsibility to provide further financial support to those infected?
Yes, on the grounds that going to court would be a horrible experience for the victims. People would die while the courts were considering it. There might be appeals. It would be a long process. Of course, it would be damaging for the government, but it would be horrible for the victims, and a little like that parallel, which perhaps is not a good one, but a little like that parallel I drew with the thalidomide case. This was a matter of saying that the law is the law, but there's also a wider issue here.
And just to try and pick up on what might have been some of the elements of that moral responsibility, you've referred there to the impact of going on the plaintiffs if the matter went to court. You earlier referred to the awfulness of HIV and the stigma associated with HIV. Was that doing the best you can now? Do you think part of your thinking that there was some form of moral obligation or moral responsibility?
Yes, I think one did feel then that there was something uniquely, as I tried to say earlier, in the social context and the other aspects of how people then suffering with HIV/AIDS were treated by others and so on, that made it different. Now, that is a hard thing to say of others suffering from other awful diseases, but there was something that seemed then to make this a unique case.
And I think I may have picked up in one of the answers you gave earlier, and forgive me if I've got this wrong, but I think I picked up a reference again to the scale. So this wasn't one or two individuals injured as a result of something a doctor had done. This was something that had happened to a very large number of people across the country. Was that part of what made it different as well?
Yeah, yes, although the horror for an individual in it is the same horror, but it was a very major event, one of the greatest catastrophes in the history of the health service.
So can we then turn to the discussions that then took place with the Treasury? We can pick it up at DHSC 0003654_115. This is a minute from Mr. Dobson to your Principal Private Secretary, 23rd of November 1990. And we can see it says, "I attach briefing material for Secretary of State's meeting next week, which has been cleared with Mr. Heppel and with legal and finance colleagues. The briefing consists of 1, a brief summary of key points to make, 2, detailed speaking notes, 3, 5 supplementary notes giving additional facts and arguments, and 4, the text of the plaintiff's proposal and Mr. Canavan's analysis." Now, before we turn over and look at any of those documents, can I just ask you to explain what use, if any, you might have made of the speaking notes?
Well, these speaking notes would have been drafted after conversation with me. These were not just officials putting stuff up. They were summarizing the arguments that they knew I wanted to use. So particularly in the key points, those they knew were the key points I wanted to deploy. Now, in a discussion with a quick and highly intelligent chief secretary, both of us well steeped in the issues, we were not going to be reading notes to each other and turning over pages and saying, "I refer you to..." It was not going to be that kind of discussion. It might have been very short. I would have walked over from Richmond House to the Treasury, and we would have had a tough but short conversation in which we fundamentally agreed about the principles that we needed to do something.
And you say in your statement, I think words to the effect that the speaking notes wouldn't necessarily reflect your own personal position.
No, you don't have the time to go through all the papers put up to you and correct them as if they were homework. Are the conclusions and what you want to say, are they useful? And officials are very unwilling to let their minister go off without, he might say something of his own bat, and that would be very dreadful. So they will always provide you with a proper speaking note, but sometimes one was allowed to escape from it.
And then if we go over the page and just look at a handful of the points that are made in the document. So this is the main points. We have a proposal from plaintiff solicitors which may offer a way of ending the litigation. The total cost, about £50 million, compares favourably with the cost of proceeding with the action, taking into account the risk of losing and going down for a far greater amount. A prolonged action lasting into the autumn of 1991 would be politically very damaging. We could present a settlement in a way that minimises the knock-on effects. We need to move quickly to avoid missing this opportunity. We will never again have the chance to settle for the sort of amount now on offer. Now, I think it's probably fair to say those 5 key points are financial and reputational points. They don't touch on any sense of moral obligation or suffering of the individuals concerned. Why would these be the points that are being identified here for the meeting with the Treasury?
Because these are the points that might win the argument. We have the 2 absolutely key points, the first and the last. The victims' lawyers have come forward with an offer that they say will be seen as fair by their clients. This will not recur. We've got to do this and do it quickly and look at the numbers. You can afford them. We can afford them. If we both knew the issues surrounding the people, this was why it had to be done now and quickly, and it was affordable.
If we then just turn on to page 5. So this is now part of the speaking note. It sets out DH view. I've consulted colleagues and leading counsel. I'm now inclined to the view that if we can secure the proposed package, we should aim to do so. And then there are 4 points put out. First is that it appears the doves among the plaintiffs are now in the ascendant. Once serious preparations for the trial begins, attitudes may harden. I think that must be a reference to the plaintiffs' legal representatives, because the plaintiffs themselves were still unaware of these discussions. Then there's reference to the cost. It said that its cost is only slightly greater than the cost of the alternative on the best of possible assumptions. And then it's the next 2 points I wanted to ask you about, Lord Waldegrave. So the third bullet point is this. There are enormous political risks in continuing with a trial in the run-up to an election. If collectively we were to lose our nerve during the trial, the cost of settling at that stage would be far greater. So it would appear that the department's view was that this could have implications for electoral success. To what extent do you recall that being part of your thinking?
Well, I think that's going to be electoral success. The election was going to be won or lost on far greater and broader issues than this. But from the point of view of health, this was an issue which a campaign was fought on and people were much concerned about. So if we could settle it, it was far better to settle it before the election. The election wasn't going to be won or lost on this. But it's really another version of the point I put earlier that we discussed and that was in my statement, that if later on the people did a U-turn and said, why haven't we settled this? What have you people been doing? You haven't settled this. It would A, be more expensive, B, it would have passed, time would have passed, and that was time was of the essence for many of the victims, and it would have just been stupid. So if you can settle it now, obviously settle it now.
And then the last point, we should not underestimate the stress which the preparations for the trial will create, particularly for the doctors who are caring for haemophiliacs.
Well, this is a departmental piece of paper. I mean, it's relative. All this is relatively irrelevant, I have to say, to the kind of meeting that I would have had with David Miller. Can you imagine one saying, "I'm now inclined to the view that"? This is me going to him and saying, "Look, there's a fair settlement within our grasp if we will pay for it and if we will move quickly." That's. I'm sure the chief medical, the doctors were saying that, and it's a real point, but it's a rather lesser point than the stress on the victims, isn't it?
Yes, and that really is the issue, Lord Waldegrave. Recognising, as I do, these are the words your officials are creating rather than your own.
Don't forget about the doctors. I don't think it was going to come into that confrontation and agreement with David Miller.
If we then go to a further minute to your private secretary in anticipation of your meeting with David Mello, it's DHSC 0003383_006. Now, this refers to attaching a supplementary briefing. I don't think we need to go through the details of it. And then paragraph 2 says we've been considering how any settlement would be presented. And so this minute, I think, sets out options for presentation. I don't think I need to ask you to read through that, but you'll note, if we just go down the page, so there are 2 options set out in paragraph 3. Present this as a continuation of the help already made available through the Macfarlane Trust, alternatively presented as a recognition that however strong our legal case is, there's a finite risk of losing in court. And then there are pros and cons set out in relation to those 2 options. As I say, I don't want to trouble you with the detail of that. But if we go over the page, it just picks up on the last point that we discussed, Lord Waldegrave. Under the heading against, there are 4 points then set out. The first refers to precedent setting for other groups. The second refers to the possibility it could be interpreted as acceptance of degree of liability for negligence. The fourth point, before we come back to the third, which refers to linking it to the special circumstances of haemophiliacs with HIV, again, it deals with the possible implications in terms of setting a precedent. But the third point says this: any suggestion of fault could harm the credibility of the department's professional advisors, the licensing system and its advisory committees. Secretary of State should also be aware that our medical colleagues are very concerned about this option since it undermines the credibility of their professional advice. Now, this is, again, it's not setting out your views. This is Mr. Dobson, I think a fairly senior official within the Department of Health, wanting you to be aware that there were concerns about the implications for what's described as our medical colleagues. It would appear from what you earlier said that was not something to which you personally attached much significance.
Well, no, that's any suggestion of fault, but I'm not involved. I'm accepting the advice of our lawyers that we are going to win the cases, or the great majority of them. This is a different sort of line of argument, which I don't see as being really relevant, that if we admitted fault, well, of course if we admitted fault, everything was different.
We then, just for the sake of completeness in terms of picking up something you said earlier, at page 5, paragraph 3, refers to the 1/3, 6/3 chance of losing, which I think we've looked at in earlier inquiry hearings in any event. So we But just before we come to your meeting with Mr. Mellor, I wanted to ask you about something that's referred to in an internal Treasury document. So it's not something you would have seen at the time, but the source is said to be the Department of Health. HMTR 602_009. So this is Mr. Edwards in the Treasury, 26th of November 1990, to the Chief Secretary. So it's the equivalent of the briefing that you were receiving from your officials, but this is essentially briefing for the Chief Secretary. Could we go to the bottom of the second page?
It's incidentally going to the Permanent Secretary and I think to the Chancellor, isn't it? So it's going to a senior Copy's Principal Private Secretary. I think that means the Chancellor, probably.
Yes, I'm not sure. It was certainly addressed, I think, to the Chief Secretary.
And Peter Middleton is the Permanent Secretary, so it's quite a senior minute.
At the bottom of this page, it refers to disadvantages of outright rejection. Again, I'm not going to ask you about the details of the Treasury's assessment. Bottom of the page then says, there seems a considerable danger that courts would bend over backwards to make awards to as many of the haemophiliacs as possible by setting an early date after which the NHS authorities could reasonably be expected to have introduced new forms of treatment, and by giving all sufferers whose precise date of contracting the virus is uncertain the benefit of the doubt. I understand from DH that there are more than 500 sufferers who might in principle have contracted the virus after the stage at which hospitals might reasonably have been expected to use different forms of treatment, even though there must be a very high probability that the vast majority of these cases would have contracted the virus well before that point. Now, there's a reference in another document also to that figure of 500. We don't need to look at it, but for the record, it's HMTR 602_011. I've been asked, Lord Waldegrave, to ask if you have any sense of where or how that figure of 500 comes from.
No, I don't think I saw such a figure, did I?
There's no reference, I think, in the documents that we've seen that passed across.
I don't remember it. I can only suggest, as I do, I think, in my statement, that this is the Department of Health trying to up the ante and sort of put some more pressure on Treasury, but I don't remember that such a figure, no.
So conceivably, I don't mean this in a pejorative sense, Lord Waldegrave, talking up what the possible implications might be in an attempt to try and get the Treasury to take it seriously.
Exactly.
If it's right, then the phrase the best available treatment is not consistent with the information which the department had at the time it made that statement.
Well,
that must follow.
Yes, I think the best available treatment line is a line that we see, or that we see it in a letter from Mrs. Thatcher in 1989, and then I think we see it then emerging later in the 1990s,
yes.
but not, I think, emanating from Lord Waldegrave.
No, it doesn't come from Mr. Waldegrave, but it's just it's an observation that if it is right, and if it does reflect the understanding of the Department of Health, which is what Mr. Edwards thinks it does, it's simply inconsistent with what was being said publicly about the quality of the treatment.
Well,
Yes.
we're at about two levels of difference, if that's the right word, from what I understood here. We're talking about a Treasury report of a Department of Health argument, which was not put to me. I was standing on the legal advice that was before me.
Yes. And then if we can pick matters up at your statement, WITN 5288001. And it's page, sorry, forgive me, no, it's page 44. Just for the sake of completeness, you refer to the 500 figure at the top of the page. But if in paragraph 4.40, if we can go a little further down the page, please. It's probably about the last 10 or 11 lines. I want to pick it up where you say, I recognised that. So you say this, I recognise that while these extremely stressful proceedings were in train, victims would be dying without the benefit of additional help, and that the public and many MPs and others would rightly think that the government was behaving inhumanely. I shared that opinion. And then you go on to say, it was not because of any exact calculus of the chances of losing that I wanted to settle. I was still firmly being advised we would probably win. I was clear in my mind that settling was the right thing to do. But it's that reference to behaving inhumanely, and you use the phrase inhumane policy later in your statement at paragraph 4.49. Would it be right to understand then from what you say in your statement that at least at the point in time in November 1990, December 1990, in which you were involved, to do anything other than settle and make some financial provision would have been, in your view, inhumane?
Yes, if it was at a level that could be paid for in rational terms, and the offer that had come, I believed, fell well within that condition.
Now,
or within that condition, though the department balks at it, saying this is on the high side and so on.
If we then go to the first of two minutes or letters you sent to the Prime Minister, HMTR 602_016, is a letter you sent to the Prime Minister on the 5th of December 1990. We looked at this, Lord Waldegrave, with Sir John Major during his evidence, so I don't propose to read through it. The question is simply this. Had you had, as far as you can recall, any discussions with John Major on this issue prior to writing this letter?
I can't recall that I had, but that doesn't mean I hadn't. There's only one thing I'd say about that minute, reading it now. It's not departmental prose, is it? I think I wrote that. It's not a draft. No, I didn't have a draft.
And then if we go just to over the page, you said, you refer at the bottom of the previous page to the anticipated meeting with the Chief Secretary. And then you say that essentially the purpose is to warn you that the last occasion when a decision other than to fight it out could be taken is going to occur in the next few days. Meanwhile, obviously, we must play a dead bat. What did you mean there?
Well, you have to defend the policy, existing policy, until you change it.
And that's effectively the idea of cabinet collective responsibility.
Exactly.
Now, the meeting with Mr. Mellor took place on the 6th of December 1990. I don't think we have any surviving record of the meeting. Would you expect it, however, to have been minuted?
Sorry, the meeting...
The meeting you had with Mr. Mellor, Chief Secretary of the Treasury, on the 6th of December.
Yes, or there would be an agreed action minute from the two departments afterwards. I would obviously, there must be some record taken of it, yes, because otherwise we'll fall to arguing about what we'd agreed.
But you, and we can look to see how you then wrote about the meeting to John Major the following day. I think it's right to understand from your witness statement, you've not got any independent recollection of the meeting now.
I'm afraid I haven't, no.
But you think issues such as the risk of setting precedents and the risk of no-fault compensation would have been discussed, those having been matters flagged up by Treasury officials?
Well, those are the essential issues, yes.
And then if we can turn to the letter that you wrote to the Prime Minister the day after the meeting, it's HMTR 602_019.
I suppose this is effectively the notes of the meeting, yes. Isn't it?
It's. I think it certainly gives us some insight into what was discussed and agreed. So I don't think we need to look at the opening page, which is your principal private secretary sending a copy of this to Jeremy Hayward, Private Secretary to the Chief Secretary to the Treasury. If we go over the page, and we looked at this with Sir John, but we can see you say in paragraph 2, I was able to go through the issues in detail with the Chief Secretary yesterday evening. We examined in particular the proposal put forward by the Plaintiffs' Counsel. We can have the next paragraph. The conclusion was that provided that the plaintiffs would commit themselves to accept their counsel's proposal, we should be prepared to accept it. And then there's a reference to pros and cons, essentially, in terms of costs, and a reference to the council's assessment of risk. And then paragraph 4 refers to you having spoken to Andrew Collins, asked him to sound out the plaintiff's leading counsel on whether the settlement would stick. And Andrew Collins reported back at Rupert Jackson's view that the proposed settlement would stick, and he would advise the plaintiff's steering counsel to accept it. There's also reference to Rupert Jackson having apparently said that the longer the affair continued, the more difficult it would be for him to get agreement from his clients. Mr. Collins is recorded there as discounting that, but believing that there might be something in it. And then if we pick up the next page, you say in paragraph 6, the Chief Secretary and I believe that we should not pass by a possible opportunity to settle this very difficult issue. You refer then to the increasing pressure to settle, not least from backbenchers. You say it would enable you to avoid long drawn-out court cases in which public sympathy would be with the haemophiliacs. It would strengthen our position in dealing with Rosie Barnes' private members' bill. The amounts payable would not be publicly regarded as overly generous. And then you say better to settle on the figures proposed by the Haemophiliacs Council if his clients support him than to bargain publicly for lower figures which would carry the risk of sparking a public auction in which the government would receive little credit and could end up by paying more. And then paragraph 7, you set out points in terms of how to handle the response. Mustn't go beyond the figure. Recipients of the new money would have to undertake to drop the existing cases and forswear bringing any future cases on the matter. All the plaintiffs would need to accept the settlement, though we may have in practice to relax this a little. And then plaintiffs' counsel would need to advise his clients that the offer provided a reasonable basis for continuing the court action. Over the page. And then the last bullet point there, terms in which we formally accepted the settlement and the basis on which it would put to the court would need to be carefully considered with our legal advisors so as to minimise difficult precedents for the future. But just before we look at a couple of other points in this letter, you don't spell out or refer to expressly, I think, in this letter to the Prime Minister what we've discussed as the moral responsibility or moral obligation. Now, one understands why you might not spell that out to the Chief Secretary to the Treasury because his concern is the purely financial. But why is that not an express feature of what you're saying to John Major?
I'm not sure. I think it's that we understood that that was in all our minds, particularly, if I may say so, in John Major's mind.
And then paragraph 8, in seeking to make our conditions stick, we have an important card to play. The plaintiffs want the agreed sum to be paid through the McFarlane Trust and so not to be taken into account for social security purposes. I've discussed with the Secretary of State, who agrees that this should be done. He also agrees that social security payments should not be recovered from the settlement as they would normally be recovered from any awards in a court case. Now, later on, when the detailed terms of settlement were being finalised, there was a residual issue about an aspect of the social security disregard and whether it should extend to certain categories of plaintiffs. But in terms of the broad principle and the broad agreement about the social security disregard, was that ever in any significant doubt, or was it a significant obstacle as far as you recall?
Well, I think Tony Newton, who was very sympathetic to this cause, removed any difficulty. The previous payments had had that benefit. There was a question whether these larger payments would have the benefit, but Mr. Newton dealt with that pretty quickly, I think.
And then paragraph 9, the Chief Secretary and I have agreed that the Department of Health must find the amounts required for settlement of the negligence cases, perhaps some 3 to 5 million from within existing provision. That's a reference to this cohort of what was described as clinical negligence cases.
Yes, and they would have been within the health service budget because the health service had such cases dealing with other matters regularly.
And then the remaining 44 to 46 million would be a charge on the reserve, probably spread between this year and next. So the outcome of your meeting with the Chief Secretary had been an agreement by the Chief Secretary that this money would be made available from the reserve.
Yes, there was a subsequent spat about that, as we remember.
There was. But do you, again, I appreciate you don't have an independent recollection of the meeting. Do you have any sense of whether it had been a difficult battle to win with the Chief Secretary?
Well, the difficulty of commenting on a question like that is that it sounds as if one's trying to take credit. I think we both knew that it had to be paid for by the reserve. A sum of that scale couldn't be found within the health service budget. But officials were sceptical about that, so it was a victory.
And then if we can pick up the Prime Minister's response to your letter, HMTR 602_020. We can see Dominic Morris, Private Secretary, 10 Downing Street, 10th of December 1990, to Mr Alcock, so your Principal Private Secretary. The Prime Minister was grateful for your Secretary of State's further minute of the 7th of December. He agrees it's right to settle this as soon as possible for many reasons. He agrees that the Health Secretary should proceed as he proposes, but it must be clear that it's Plaintiffs' Counsel's proposals and his figures. Plaintiffs' Counsel must get agreement from his clients to accept before the government could announce figures. Until then, it's very much Plaintiffs' Counsel's initiative. Now, we looked at this with Sir John. I flag it up to you, Lord Waldegrave, because I'm going to come on in a moment to ask you about the way in which the settlement was announced. So that there is the Prime Minister's stipulations, for want of a better word. It's likely, is it, that you would have seen this as it's recording the Prime Minister's decision?
Either seen it or my private secretary would have rung me and said he's agreed or something, yeah.
And then if we can turn then to HMTR 602_021. Now this is, I think, not a document that you would have seen at the time. It's from Jeremy Hayward to the Chancellor, and it says in the following, but it refers to you, so hence the questions. It says in the first paragraph, as I told you, Mr Waldegrave wants to announce this afternoon that the government has agreed in principle to accept the proposals put forward by the Plaintiffs' Counsel for an out-of-court settlement. Mr Waldegrave's office have supplied their proposed text to us, copied to you. Crucially, Mr Waldegrave apparently wishes to make this announcement whether or not the steering committee of lawyers representing the haemophiliacs has signalled its agreement to Council's proposals. This is, of course, completely at odds with what the Chief Secretary agreed with Mr Waldegrave last week and inconsistent too with the Prime Minister's view. Having discussed this with the Chief Secretary, I've suggested to Number 10 and to the Department of Health an alternative form of words against the contingency that the steering committee does not agree to the Plaintiffs' Counsel's proposal this afternoon. And then you can see there, Lord Waldegrave, the alternative form of words is essentially just referring to the ongoing discussions. And then if we go over the page, Mr Hayward continues, Number 10 thought this was exactly right. The Department of Health did not. Mr Waldegrave phoned the Chief Secretary on the car phone to make clear his view that a public announcement that the government was prepared to deal would in fact help to secure the steering committee's agreement. The Chief Secretary expressed the contrary view and stressed that it was not in Mr Waldegrave's own interest to do anything that would increase the risk of the government being driven to accept a more generous settlement. The Treasury had already been more than generous. The Chief Secretary believes that we should now leave this to the Prime Minister's political judgment. I'm fairly confident that Dominic Morris will suggest that the form of words above is more appropriate, unless, of course, the steering committee does agree today with the Council's proposed settlement. And then before I ask you about this, Lord Waldegrave, if we go back to the first page, the handwritten note at the top says, the PM has now gone along with the Waldegrave proposal and has announced that we are settling. Now, we'll look at what was said in Parliament by you and by the Prime Minister. But first of all, do you have any independent recollection of the issues and concerns that are recorded in this minute?
Not independent, no, but not independently, no.
But having looked at the documents, first of all, do you have any reason to dispute the accuracy of what's set out here by Mr. Hayward?
No, none at all. I mean, I have no independent no independent recollection.
And doing the best you can, lacking that independent recollection, why was it that you wanted to announce the in-principle acceptance of the proposals, whether or not there'd been any agreement from the plaintiffs' representatives?
Well,
and and in circumstances where the plaintiffs themselves clearly would not have agreed.
Well, two things. As is said in that minute, I'm not going to get any more money. There's the threat from the Chief Secretary saying it's in my interest to do what he thinks is best, because I won't get any more money. Second, looking that weekend, I think, or that Monday, I can't remember, at the tactics proposed that I'd agreed with the Treasury, they are very foolish tactics. The idea that more than 1,000 people could agree, and only at that point, when they'd all agreed, would we say that we were going to accept the offer from their side, would be bound to result in a public auction. And as I'm being warned by the Treasury, I won't get any more money for that. So there was a real risk that the whole deal was going to come to pieces at that point, and we'd be back where we were. So that concentrating on it, I don't know what else I was doing that weekend or where I was, concentrating on it, it seemed to me that what I'd agreed and what the Treasury thought was a good thing to do was bound to fail. And therefore, I put to the Prime Minister clearly that we should do it in the other way, which then worked. And I'm glad that I did that, because having a momentary froideur with the Treasury was well worth getting what I thought and what Mr. Rupert Jackson thought and Mr. Andrew Collins thought was a fair deal through and done. And it worked. And the Treasury grudgingly later on say, oh, well, Mr. Waldegrave's plan worked better than we could have thought. So we did the right thing. That deal could have come apart, and I think I did the right thing I did the right thing. The Prime Minister did the right thing by accepting my advice that we should do it the other way.
Now, it might be said that by doing this, making the announcement as was made on the 11th of December 1990, that it was effectively precluding the plaintiffs from seeking more.
Well, no, all the plaintiffs have to agree, and the court has to agree. I mean, that's in my written answer, it's in what the Prime Minister says. They all have to agree.
But as I understand your answers and what you say in your statement, the reason or a reason why you approached the announcement in the way you did is because you thought that there was a risk, if doing it otherwise, that the whole thing would break down.
Yes.
We looked with John Major at his announcement. I won't go back to it again. It was an oral answer on the 11th of December. For the record, it's DHSC 0003654_003. It's an announcement that says we've been able to agree in principle to proposals put forward by the plaintiffs' lawyers. If we can just look at your written answer, DHSC 0004415_036.
I should say that there's a small mistake in my written statement, which I should have corrected, which I refer to this as a written statement. Of course, it's not. It's a written answer.
And for the benefit of those who may not be as familiar with parliamentary procedure as you, what's the difference between the two?
A written answer goes down if there's a question. Obviously, Harry Tolman had a question down before about something or other, well, about this subject, and the answer to her can go at the last possible moment that the table office will accept it. I can't quite remember when that was. A statement is something that is, a formal statement is something of which you give the opposition notice, and it's a more formal procedure.
And if we go, first of all, to the bottom right-hand corner under the heading HIV, we can see Ms. Harriet Harman's question to ask the Secretary of State for Health what representations he's received from organisations and individuals in respect of an out-of-court settlement for people who've contracted HIV through NHS service-infected blood or blood products. And then we have your answer over the page.
It was, incidentally, it's a trivial point, but it's a bit of luck for us that Harriet Harman had a question down, because we couldn't have put a new question down at the last moment.
And of course her question was about
the
representations,
yeah.
rather than a question about settlement. And then you say this, the Steering Committee of Solicitors representing the HIV haemophiliac plaintiffs and their counsel have put forward to the Department of Health proposals for the settlement of this litigation, which they regard as a fair and reasonable resolution of the plaintiffs' claims. The government have carefully considered these proposals, agree they will provide a fair and proper way of ending this litigation and of making financial provision for all affected haemophiliacs and their dependents, whether or not they've joined in the litigation. We believe that our case is legally strong and that the plaintiffs would not succeed in proving negligence on the part of the Department of Health. Nonetheless, the government have always recognised the very special and tragic circumstances of the haemophiliacs infected by HIV and of their families. We recognise too the harrowing effect legal action would have on them. The government have therefore agreed in principle to meet the steering committee's proposals. In outline, the compromise would result in the government providing to the Macfarlane Trust, in addition to the £34 million already paid, a further sum of about £42 million for distribution to all haemophiliacs and their families according to their respective circumstances. Furthermore, the government have agreed that payments from the Macfarlane Trust will not affect entitlement to social security and other statutory benefits. The plaintiff's reasonable legal costs would also be paid by the government. Because the proposed settlement will require the formal approval of all individual plaintiffs, and in the case of minors of the court, it would be inappropriate at this time to publish further details until all plaintiffs in the court have had an opportunity to consider the full terms of the settlement and to approve them. The government would apply the outcome of any settlement to all parts of the United Kingdom. The government welcome these developments, which offer a speedy way of ending the lengthy period of uncertainty for haemophiliacs and their families, and of giving them additional financial security. Again, is it right to understand that the purpose of identifying the figure of 42 million, so the global figure, not yet identifying the individual amounts that might be payable to different categories of plaintiff, is this right, as I understand your evidence in your statement and your oral evidence? There's essentially two reasons for referring to the figure. The first is it gets out there into the public domain that which the Treasury has agreed to.
Well, yeah, I mean, the first purpose is to say that that's the figure put forward by them, which we will accept.
And the implication being that there isn't going to be the public auction, there isn't going to be a negotiation for any higher amount.
Well, of course, if the individual plaintiffs, or indeed the court, had subsequently disagreed with those figures, it could theoretically have all come to peace. I think as I said to you before, I'd come to have a very high regard for the professionalism of the lawyers on both sides involved in this, and I think I took it perhaps unwisely, but it turned out to be right, that when Rupert Jackson said they will accept this, that he knew what he was talking about.
Can we then look, I think the last document on this issue of how the announcement was made, at HMTR 602_023. This is from Strawn Heppel in the Department of Health to Mr Edwards in the Treasury, 12th of December 1990. It refers to and attaches a copy of the Steering Committee's press release. I don't need to ask you about that. It's just to give you an opportunity to comment on what's written in handwriting there. And our understanding is that's written by Mr Edwards, the Treasury official, and it's addressed to the Private Secretary, to the Chief Secretary. It says this: vexing as DH's handling of this was, it turned out as well as or better than we might have expected. There's then an X1 is encouraging, that's a reference to something that's said in the text of the minute. I will, however, make clear again to DH that this was no way to do business. In the meantime, I've asked them to ensure that their press office gets across the point that the government has already provided £34 million. Do you have any observations on what's said there, or any understanding of what might have been referred to as vexing or no way to do business?
Well, I had persuaded the Prime Minister that their tactics were likely to fail, and they turned out to be right, and it's very vexing to be shown to be wrong.
So I'm going to move, I think, to a later stage in the sequence of events next. And bearing in mind the time, it might be sensible, rather than starting on that in the next 3 minutes, to do that after lunch.
Very well. Well, let's take a break now until 2 o'clock. 2 o'clock.